Good evening, sir.
So today we'll just conclude with discussion of e-contracts because now we should be moving ahead to some practical aspects. So e-contracts we have dealt in detail that what kind of contracts, what are the transactions, who is the person who originates the message, who is the person who has been addressed. Now there are two main categories to e-contracts. What are those? First main type is which have been categorized on the basis of executing that contract, and we generally come across these contracts but we do not give that much of heed to them. First of that type of contract becomes your shrink wrap contract. Yesterday we stopped at this particular topic, shrink wrap. Now what does the word itself say? One is shrink, one is wrap. Now what it gives my presumption in your mind? What do you understand by this thing? Okay, anyone is having any knowledge about this, or even slightest knowledge about this, read about or heard about this? No. For example, uh, we purchase some electronic device, or let's assume there's a software that's in a packet, correct? The moment we open that particular packet, the moment we open that leaflet or that booklet along with that particular cd-rom or anything, the terms and conditions in that particular browser that become binding on both the parties. Is it so? For example, we purchase some software that has been delivered. Now the moment we unwrap that particular packing, terms and conditions are applicable on both the parties, liabilities and other things. If it says that now your guarantee will be for next 1 year, so the moment you have done this particular act of receiving that particular product, and now you have opened that packaging, this contract is executed. Anything difficult to understand in this? That is why it is called shrink wrap contract. Correct? What about others? Now, next type of contract is click wrap. What is click wrap? We yesterday did that example. That the moment you press the I accept tab, your contract is executed.
Yes, sir.
One is shrink wrap, other is click wrap, and third one is browser. Now you have to understand what is a browser e-contract. For example, browser is, it takes you from one web page to another. For example, you search some say product online, correct? On the first web page, on the opening page, it's only a 3D hologram or 3D image of that product. Then it says for specifications, click here, correct? You click on that, it takes you to the specifications. Below that there must be anything which is like uh, other buyer, other sellers, similar products, terms and conditions, return policy. So this is how it navigates you in between the pages, web pages. But it does not conclude the contract there. First you have to go through that particular streamline channel, first web page, then correct, put click on that details description, then it goes to another web page. Isn't so? Is it understood?
Yes, sir.
The
No,
difference
it
is,
is understood, but what is the
listen,
relevance from a our learning point of view? That why these are different.
because see, they are different because of the servability. For example, if we are selling say some kind of software, correct?
Mhm.
Let's assume that mostly mutual funds. The moment you read the terms and conditions, you click I accept, done, correct? If you are purchasing it
Mhm.
online, But if you're purchasing a product for which you need to understand the descriptions, you need to understand each and every minute details,
Okay.
then browser browser wrap contracts are necessary. Why we are dealing it today is because now the most important aspect is that you will understand one thing. Be it click wrap, be it shrink wrap, be it browser. What is the main thing which is common in between all of these three?
It's a
What is-
contract here.
No, it's a contract.
Uh,
But the main thing is that these are standard form of contracts.
mm-hmm.
You receive it as it is.
Mm-hmm.
They have been pre-drafted. They are standard form of contracts.
Mm-hmm.
That means in these kind of e-contracts, you do not have that particular privilege of negotiation,
Getting it modified. It is
amendment,
what is available.
correct? And thirdly, when these kind of contracts come in front of you, what does it signify? It signifies take it or leave. Isn't
Mm-hmm.
it so?
Correct. Yes.
If you are requiring anything that is served through these contracts, one, that's these contracts are standard form of contracts. You cannot do anything in terms of modification or any alteration, no customizations.
Correct.
Second,
Mm-hmm.
any of these kind of contracts, they are on the basis on the primary line of take it or leave it. That means it's a unilateral contract.
Mm-hmm.
Correct?
Got it. Okay.
Now we'll be moving to the next aspect, that is standard form of contract over here. Now, for example, what are the examples you encounter on daily basis of these standard form of contracts? Everyone is aware about these contracts. Any example? Yes. How many of you have booked, say, rail tickets online
Yes, sir.
or through counter?
Book through online.
What is the procedure? You put the date of departure, you
Yes,
put
sir.
the criteria, what is the categorization, time, your choice of sleeper or AC or whatever you want,
Yes,
correct?
sir.
Then a ticket is generated.
Yes, sir.
When an e-ticket is generated, there are certain things which are written. For example, it says if on the date of arrival you are not
Present.
present, this will become
The refund.
forfeited. You cannot
Yeah.
for example, if there is refund,
Yes,
say
sir.
24 hours before the date of departure, then only
Mm.
70% will be refunded.
Yes,
30%
sir.
will be for confiscated as a charge. Correct?
Yes, sir.
So now what are all these terms and conditions? These are standard form of contracts because now for millions of transactions of a similar nature, they cannot keep a individual contract. Next best example is, how many of you have opened your bank accounts? Everyone? When
Yes,
you
sir.
go to the bank, what do they give you? Application form
Yes, sir.
with 2-3 pages overleaf,
Yes, sir.
standard form of contract. Similarly, insurance policies. When you apply for some insurance policies, be it vehicle insurance, be it health insurance, or anything, third party or any kind of insurance, these are all standard form of contracts. Now we have to understand one thing. Is it the way that because of the reason that they are standard form of contracts and we are under a compulsion that if we need to get those services or those things from those contracts, we have to execute them? Then next question will be that the person at a lower pedestrian will always be exposed to damages, isn't so? A person at a higher leverage will always try to assail certain kind of terms and conditions which are only favoring him, correct?
Yes, sir.
So now the next question is, how will it be safeguarded? Now, first of all, why are these kind of contracts generally drafted or used? Any basic idea about this? One is speedy, other is economy of scale. It reduces cost, correct? isn't so? And if a person has a monopoly over certain aspects, so they can safeguard that monopoly also, they can leverage that monopoly, isn't that?
To safeguard their interest.
So next thing is that there is no bargain, no negotiation. So this is the only negativity in this kind of contracts when it is a standard form of contract. Other positive things remain same. Correct? Now, it says you cannot always plead victim in this, that these are standard form of contracts, so we fell prey to this, isn't so? The easiest defense would be that we executed this and we fell prey to this, isn't so? Then you have to again go back and check the details of those contracts. There was a case, that's L. Estridge versus Gurcab Limited. What was this case all about? It was a case where plaintiff was a purchaser. So purchased a online. He purchased online a cigarette vending machine. Correct. But on that particular cigarette vending machine's terms and conditions, it was written that if in any case the machine is faulty or gets any deficiency, then the manufacturer will not be held liable. Correct? Irrespective of this fact, the plaintiff purchased that product. So next thing was, he saw that the machine is not working. He moved to the court. Court said that even if this is a standard form of contract and you have executed it and suffered certain damages, yet there was nothing that can be called as misrepresentation. Can it be called as a misrepresentation?
No, sir.
So first thing in your e-contracts, you have to analyze that is there anything which is hidden. If you are claiming any damages, then the first thing to cross check in your e-contracts is that was anything which is not disclosed properly. Is there any representation which has been concealed, be it a representation of the product, services, quantity, quality, or anything which has been delivered in any means. So you have to see whether there is any kind of misrepresentation. Then only you can say that because of the standard form of contracts, this particular thing was executed, and due to the deliberate concealment of the fact in these contracts, this damage has occurred. Correct? Otherwise, in standard form of contracts, the person who is making an offer or invitation to offer will always have a leverage that this was always a full representation, and after going through all these representations, you have executed these kind of contracts. Correct? Now, terms
Sir,
and
what's
conditions.
the
Yes.
sir, what's the difference between adhesion contracts and standard form of contracts?
I was just coming to this. This is the next thing which we are knowing to.
Okay.
See, now, scope of negotiation, we have already discussed that it works on the concept of take it or leave it. Now, this is also known as contract of adhesion, that you have to obey by the commands which have already been negotiated in those kind of contracts, because these are set formats. Now, these terms and conditions, there are certain clauses in these contracts which are known as boilerplate clauses. Now, you have to understand that what is a boilerplate. What do you understand by boilerplate? This is a concept. Yes. Anyone aware about boilerplates? Nobody? It says there are certain clauses, because it's to be drafted in a way. There are standard forms or common practice that synchronized way of drafting of a contract is there. But now you have to understand boilerplates are those clauses without which any of the contract cannot work. or be complete. They can be interchanged in the place of mentioning. For example, can a contract work if there is no termination clause? Can a contract
No,
work
sir.
if there is no clause for unforeseen, unpredictable circumstances? Can a contract work without any exit clause?
No, sir.
Similarly, can a contract work without jurisdiction, establishing a jurisdiction, or which law will prevail in terms of
No,
dispute?
sir.
Correct. So these kind of major clauses, they are known as boilerplate clauses. Correct. So when you are looking into any kind of e-contract or any contract, traditional contract, these particular clauses will be experienced by you always. They can be interchanged. It can be in mid of the contract. It can be at the ending part. It can be on the opening pages. But there will be these clauses, because without of these clauses, no contract can function properly. Now, because understanding these kind of damages and these kind of exposures of the party who is at the weaker negotiation, courts have also developed certain rules and norms to safeguard them, at least to eradicate exploitation. Now what does court say about it? It says there should be a contractual document. Now contractual document will only be when there is a document which has been signed by both the parties of the contract. Yes or no?
Yes, sir.
But in case of e-contracts, is there any kind of such document? No. But to that extent, we yesterday did Section 10A of Indian in this IT Act 2008, which identifies these kind of transactions, these kind of contracts. So it says there's one more concept to this, that digital signatures, that you have that unique ID, you have that IP address, and that is termed to be the valid signatures of yours.
Yes, sir.
Yes.
So it says there should be a contractual document first. For example, if you purchase something and after purchasing that, they give you an invoice. Correct? Now, on the backside of that invoice, there are certain terms and conditions which have been written. For example, it says if you have to replace this product, if you have to return this product because of anything, you have to return it within 7 days. There is no policy of return, or there is only a policy of exchange, getting the exchange. So you cannot just return it back and take, no refund is there. So if these kind of terms are written overleaf of your invoice, then this becomes a contractual document. Correct? Now, next thing is, for example, if it is not saying anything about, for let's assume in this invoice particularly, they are not saying anything about refunds, then we can always challenge that this is a contractual document, even if it's a standard form of contract, but it has not been properly represented. Terms and conditions are vague or silent to some extent.
Yes, sir.
Just because we were at the pedestrian where we had to avail the services, or we had to execute this contract, we were compelled, or we were in that particular position where we cannot deny this. So then we can claim that any fraud, mischief, or coercion was there. Now, next thing is, even if these contracts, even if these standard form of contracts are there, they should have reasonable notice. Correct? Terms cannot be informed after executing your contract. For example, a proper notice must be given to a person giving the document to give sufficient information. Now, you must have seen rail tickets, traditional rail tickets. On the front face, it was always mentioned time of arrival, then departure, when it will be reaching, which platforms it will be stopping, correct? And on the backside of that rail ticket, there were certain terms and conditions. So that means once you have executed, you have been reasonably informed that a reasonable notice has been given. For example, if it says if you're traveling with some arms and ammunitions, then it will be illegal. First, second, for example, it says you cannot bring a luggage of say more than 20 kgs. So it becomes clear in that. Or if we travel by air, there's a certain quantity of luggage which is allowed inside.
Yes, sir.
So you cannot say that these kind of things were not notified to me. So a reasonable notice has to be given in these kind of contracts, even if they are standard format. I'm saying this because now today, generally what happens is these kind of contracts are put before you. And if any dispute arises, then you have to go back and read between the lines that whether proper representation was there. First dispute will always be on the product. For example, the product was not delivered proper, it was not as per the representation, it was not, for example, if it says online Amazon shows a dark red color of the product, but when it reaches to you it is something different shade, different color, or let's assume it's a pink color product, then representation was something which is misrepresented. So my consent or my consideration was for that particular product, so this is not a proper thing, so I can claim damages. Secondly, reasonable notice. For example, if there are certain contracts, standard form of contracts wherein terms have not been disclosed upfront, if those terms were disclosed upfront, there would have been possibility that I would have not executed that contract, even if it was a standard form of contract. So terms, reasonable notice should also be there.
सर
Now,
एक चीज पूछनी थी
yes,
सर, जैसे आप कह रहे हैं कि रीजनेबल अपफ्रंट में आपको बताना चाहिए कि कब जैसे कॉन्ट्रैक्ट क्लोज होगा या क्या ड्यूरेशन रहना चाहिए, कोई इसका वो एजम्पशन नहीं होता कि मतलब नॉर्मली अगर कोई चीज नहीं मेंशन है तो नॉर्मल ड्यू कोर्स में मान लिया जाएगा कॉन्ट्रैक्ट टर्मिनेट हो गया, या फिर जैसे रिफंड वाली बात है, रिफंड वगैरह नॉर्मली हम नहीं देना चाह रहे तो हम नहीं लिख रहे उसके बारे में, तो मतलब इज इट नेसेसरी हम लिखें कि हम रिफंड नहीं देंगे इस चीज के लिए?
see, for example, I'm just saying reasonable notice means that major issues pertaining to major things. Let's assume if a rail ticket does not disclose that this travel for this particular duration over this rail for this date is not insured, what will happen?
हाँ, तो मतलब ये तो कॉमन मतलब नॉर्मली बात है ना कि अगर हम 20 तारीख हमने टिकट बुक करी है, 20 तारीख को हम नहीं पहुंचे तो ऑब्वियसली कैंसिल हो जाएगी हमारी।
Sir, but let's okay. One more thing. If there is any cosmetic thing, which is cosmetic nowadays, we make those things. They make us sign a declaration.
यस,
What is it written? That in case if anything happens or such things. But that is also presumed that once you come and sit in that chair, you know all the adverse things.
हाँ,
But still they disclose to you major things.
यस,
So that is reasonable notice.
हाँ, होने वाले जो इफेक्ट्स होते हैं वो
Probable.
हाँ, प्रोबेबल
Correct.
इफेक्ट्स।
Probable effects. To that extent, it is called as reasonable notice.
ओके,
Representation is okay, that this service will be given to you. For example, Botox treatment will be given. But notice, reasonable notice is not there. For example, what it says, in case if it discloses before you sit in that chair, it says you sign this declaration. The declaration is very much clear. It says in this particular duration of surgery, if anything happens to the patient, we are not liable.
ओके,
So this is upfront. This is notified to you. But these are all standard form of contracts.
यस,
If you want that surgery, if you want that treatment, you have to sign that.
या,
Correct? So now, notice should be contemporaneous with the contract. Companies, mostly in standard form of contract, wish to discharge their liabilities. generally because they have an upper hand, so they try to discharge. Sometimes exclusion clauses are mentioned. Example is, if my defect in our product occurs, we won't be held liable. If such a clause is mentioned in your contract, the second party should in advance have the knowledge. Just like the case we discussed, cigarette vending machine was there, but it was a open statement on that particular standard form of contract that if any defect occurs, we are not liable. We are just selling this. After letting you know about this thing, you have executed this contract. So now you have waived your personal right, saying I was not upfront notified about this fact. So that is why this is the help standard form of contract gives to the developer. Now, it says reasonable terms should be there. Nothing unreasonable should be there. For example, there's a person who has a monopoly over a product, correct? That doesn't give him an upper edge that they can put any kind of term. That if you want to purchase this, then you have to say abide by this, that you have to say after sale of this particular thing, you have to take services, after sale services from us only. What if they don't want it? They just want the product and move. You cannot bind them. So if it's such kind of terms which are unreasonably bounded over them through some standard form of contracts, they become void. You, to that extent, those terms can be severed off. That is, we can dissect them and move. We can say other contract remains perfect, but this is unreasonable clause in this standard form of contract, it will not be applicable.
सर जैसे कि
Yes.
जैसे हम कोई भी गाड़ी कुछ भी अगर हम लेते हैं तो उसमें एक ऑलरेडी एक इनबिल्ट क्लॉज होता है कि अगर आप फर्स्ट ईयर या जितना भी पीरियड ऑफ वारंटी है
जी,
तो उतने टाइम के लिए आपको कंपनी से ही सर्विस करानी पड़ेगी,
करेक्ट।
तो वो क्या फिर अनरीजनेबल हो जाता है?
बट वो आपको गाड़ी परचेज करने से पहले ही तो नोटिफाई कर दिया उन्होंने।
हाँ, नोटिफाई कर दिया,
बट कुछ अनरीजनेबल मान लीजिए, ये
गाड़ी तो
कहते
नहीं है
हैं,
ना।
मान लीजिए वो ये कहें कि अगर गाड़ी डैमेज हो जाती है तो हम सिर्फ आपको डैमेज का सिर्फ 15% देंगे जी।
ठीक है, वो अलग चीज है।
तो वो तो अनरीजनेबल है ना।
हाँ।
इफ आई हैव परचेज्ड इट फॉर से 100 rupees, they'll say we'll only indemnify for you for 10 rupees. This is unreasonable, unfair trade practice.
यस यस,
करेक्ट।
हम लोग जो एज पर लॉ, मतलब जैसे कि अगर इंश्योरेंस है तो इंश्योरेंस के जो लॉज हैं उसके हिसाब से मतलब जो कैलकुलेशन होती है।
That's why I said when we did yesterday that nothing withstanding, जो कल हम लोगों ने किया, nothing withstanding, that law will take its course. You cannot alter that law. You cannot say that by virtue of being executing this contract black and white, now everything is applicable. If it goes against the law, that is unreasonable.
Okay.
Correct? Now, terms of contract should be reasonable. Now, there's a case Lily White versus Manu Swamy. Plaintiff gave sari to a laundryman. Correct? Laundryman issued a ticket, receipt. Now, what happened in that? That receipt was saying, if in case of any damages, I will only bear, say, 15% of the damages. If your sari's cost is, say, 100 rupees, I'll only give you 15 if it's damaged. Correct? Now, what happened? This sari was lost. So, by this particular injury, that the person who was the owner of that particular thing, she claimed full value. Correct? Court held that term and condition of 15% of market value was unreasonable. That you cannot compel anybody, because see, the damage is for 100. You cannot say that I can only cover 15. So this is against the public policy. This is not ethical. So it will not be termed as a valid clause in your contract.
Okay.
Because one other rule when we interpret these contracts is, when you go in the disputes, contracts, see, when we interpret contract in terms of, say, insurance law, let's assume it like this. When we argue those cases for the insurance company, we say strict interpretation of the contract. That means we have to go only by black and white, which has been mentioned in the contract. If it's for example, mentioned in the contract that if insured uses his vehicle for, say, some racing purpose or other than against the norms of MACT Act, then we will nullify the insurance. Correct? So insurance gets waived off the moment it comes to the knowledge that this accident occurred because of the negligence of the insured. So in those cases, strict interpretation. See, now precedents might be, it's just to make you all understand that when we argue in support of a contract, we say that strict interpretation. But law also says that in case any reasonable thing is there, it can be taken on record. But if it's unreasonable against the public policy, that will go. That has to be detached. Now, it says the court makes the strict construction of the contract to give protection to the weaker section in case where the party to the contract do not have bargaining equality, just like in our standard form of contracts or these contracts which are executed online. These are all having standard form of contracts. They're already pre-drafted.
Yes, sir.
So we are at the weaker pedestrian. Court says at least to safeguard this particular section of the society who are in this particular ambit, who are on a weaker note, that they do not have that bargaining power. Now the check is to be kept that anything unreasonable, anything which is not notified at the time of execution of that contract, or any misrepresentation during the contract, that particular execution of the contract is there, that has to be cross-checked. It says, yes. Now it says liability in tort will arise from this kind of practices. For example, if a company misrepresents in a standard form of contract, any means they are vicariously liable. The court wants to keep a strict interpretation of exemptions. Now let's assume there was a case. I'll just help you out in this. See, there was a case where a person purchased a cycle. So let's assume A purchased a cycle from B. Correct? Now, when he purchased, in that particular sale purchase, B never disclosed the malfunctioning of that cycle. That when the cycle is driven, its saddle goes off. This was the thing. Sale was executed. Everything was mentioned that now, here and after, the person will be dealing with this. Mr. A encountered certain injuries. Can Mr. B, because this is not the part of the contract, can Mr. A claim injuries or damages? Yet there was a standard form of contract over there.
Yes, sir.
Under what law? It will go under law of torts.
Thoughts.
So this is how, even if you are executing any e-contract, you can have the remedy. Now, theory of fundamental breach is also to be seen. Let's assume in a standard form of contract, when you are taking a, say, bank loan, rate of return was applicable. Let's assume it is a, say, home loan. It was prevailing at that time, and it was mentioned that 8% will be charged interest rate. Now, bank cannot claim 10% here and after, saying that we have already mentioned that in case of certain things, we will increase it by our own wishes. If we feel that this is not the exact correct rate of return now, or sorry, rate of interest. So even if it has been mentioned, but you cannot say there is a fundamental breach. Understand it like this. You availed a loan at the assurance that it will be at 8% interest. Now bank cannot say just because the market has fluctuated or something, because now it's a fixed rate of interest. It's not on floating rate. If it was on floating rate, then they have to represent you on the upfront before granting or executing that agreement for taking that loan. They have to mention this thing upfront, that this loan will be always on floating rate of interest as per the economy, as per the market indices. But when they have mentioned this, that even if it's a standard form of contract, they cannot say now we'll change it. So if there is any kind of such fundamental breach, then also we can claim our damages. Now there's a case of Alexander versus Railway Executive. What was this case all about? Which talked about fundamental breach. It said plaintiff kept luggage in a clock room. Everyone is aware about the clock room. Railway stations, we generally keep for a shorter span of time, we just put our articles over there for a safety measure, that this will be kept for, let's assume, for 2-3 hours, we keep in that clock room. Now ticket was issued and this luggage went missing. Now clock room authority misplaced this luggage because now they were interested with this particular duty. They misplaced this luggage. What was the alternative to this? He sought his damages. Court held that railway has done a fundamental breach. Now, what is the fundamental breach? That in the clock room, the first thing, the common understanding is that they have the duty to safeguard your product or your article. Now, if that fundamental breach is there, it is not to be mentioned upfront. This is a common understanding between the parties, that if I am keeping this in the custody of that particular service provider, and that service provider is assuring me or taking any kind of consideration from me for that particular work, so even this is a common understanding. This is by virtue of the transaction that I come to know that this will be the fundamental thing. That's the duty. So court held that there was a fundamental breach of duty on account of the railway authority to maintain that property or luggage. So the person has to be indemnified. Yes.
सर इसमें एक चीज ये है कि क्या वो रिस्ट्रिक्ट कर सकते हैं अपने लॉस को?
कौन?
रेलवे अथॉरिटी, मतलब इतने तक के लिए हम लायबल होंगे, ऐसे जैसे होता है.
The service they are providing, for example, इसी एग्जांपल को लेते हैं, सर्विस वो दे रहे थे क्लॉक रूम. क्लॉक रूम itself means safe, secure possession.
Yes, sir.
Now, even if this is not mentioned in their standard form of contract, and any fundamental breach is there, this is their duty. Their duty bound to indemnify you.
Yes, sir.
So I am saying, even if there is a standard form of contract, you can take this defense that there was a fundamental breach. Let's assume a service provider says there's a standard form. It says, if you will give me, say, you have to purchase the software, I'll give this software with this specification. But the moment you get the software, it is something else.
Yeah, that is totally fundamental breach.
Or you made the payments, everything got, acknowledgement is there, everything is there. But now they're not delivering you the product for no good reasons. Fundamental breach.
Yeah.
Or there's a clause which says in that standard form of contract that the delivery of this product will be, say, through railways or say waterways. But they have not insured that transit. Product or that particular consignment is no more. In between mid-sea, it sunks. Now they are not even reimbursing your product or giving you anything. So this is fundamental breach.
That I understand. I am asking that can they restrict their liability towards fundamental breach?
They cannot. That's why I'm saying fundamental breach. How can you restrict a liability in a fundamental breach? It has to be incomplete.
जैसे बैंक्स में होता है फंडामेंटल ब्रीच, जैसे कि क्या होता है, बैंक प्रोवाइड यू लॉकर एंड फॉर दैट यू पे लॉकर रेंट, बट ओनली अप टू 1 लाख रुपीस बैंक इज लायबल फॉर अगर लॉकर में से कुछ भी चोरी होता है, अगर वो 1 लाख रुपए से ज्यादा का है, तो बैंक विल ओनली इंडेमनिफाई यू 1 लाख रुपीज। तो उन्होंने रिस्ट्रिक्ट कर दिया ना अपने आप को 1 लाख रुपए तक। अगर मैं अपनी गोल्ड या ज्वेलरी अगर 10 लाख रुपए की रख के आ रहा हूँ, बैंक में चोरी हो जाती है या बैंक के किसी स्टाफ ने चोरी कर लिया, तो वो मेरा बैंक तो कह रहा है कि मेरे को 1 लाख रुपए तक का ही आपको इंडेमनिफाई किया जाएगा।
नहीं, उसका वो देखना पड़ेगा, बिकॉज इफ यू आर सेइंग दीज आर द फैक्ट्स, बट आई अंडरस्टैंड दीज आर नॉट द फैक्ट्स, बिकॉज my mother personally had a locker and I was dealing in that, but this is not the way that, well, you might be correct, but to my knowledge I have never encountered this kind, because whatever value of asset is there, nobody is aware.
Yeah, nobody is
Because nobody is aware about the valuation. So in that case, it's not a fundamental breach. If bank says I am giving you only a locker facility, correct? Now whatever money has been there, because of the secrecy, nobody knows. Only the person, locker holder, knows it. The best thing is, if, for example, if somebody steals or something, some mishap happens on account of the bank, they are not able to, provide proper security. That becomes a fundamental breach. But if they are restricting their fundamental this indemnity only to 1 lakh, then it's your decision, because now they are saying only 1 lakh. So you have to make a decision that whether you want to put a property in that beyond 1 lakh or not. Nobody is calling you.
Yeah, that's true.
So that's not a fundamental breach. That's only restricting their liability, limited liability.
Okay.
Yes, Anju, you wanted to ask something? You raise your hand. Okay, let's move further. Now, nothing to understand why people take these kind of contracts, why they accept these kind of contracts. Because after a time, person enters into a contract. For example, in say Play Store, we all know when we are downloading a software or anything, they will ask for this, that I accept, I give permission for using my locations, for using this, I give permission to send them messages, for send me updates. So now, because of those regular transactions, we are also not in that particular query mode that we'll keep on asking. So that's why we also execute that. Okay, this is the random day-to-day transactions and nothing material is there. So that is not concealed. So we also. Now it says Section 16 and Section 23 of Indian Contract Act provides for void contracts on ground of undue influence and opposed to public policy. Moreover, the mechanism evolved and applied by the contracts help to great extent in protecting the interest of weaker party and solve the problems of standard format of contract. So it says 16 and 23 of Indian Contract Act, they deal with this. Now, what is 16 and 23? You all have your Barrett's? 16 is undue influence, be it coercion, be it because of the higher pedestrian or things. 23 is, let me just go through. About consideration and objects being unlawful. For example, if a website says standard form of contract is, it says that if you execute this contract, we'll serve you the packets of contraband. So unlawful object. Consideration, for the CD player, we'll serve you the pornographies and all. So this is also unlawful. So these kind of things help to safeguard the. Now there was a case where it said reasonable notice. Again, an additional case was there, Ole versus Marlboro. It said that the party went to a hotel, they booked a room, and the information on the door's backside of the room was there that hotel is not responsible for use of loss of personal belongings. On the backside of the door, they must have, and the property was stolen. Court said that reasonable notice by the time of signature of the contract was not there, because they have to update when they were booking the room, This reasonable notice was only given when they have already executed and they have already booked a room. Now, it said that a reasonable notice means before executing any such kind of e-contract, reasonable notice of that particular thing needs to be provided to you. That you should be up, major things should be clear to you. Anything which is still having anyone who is having doubts, because we will be moving to the boilerplates now.
Sir, I actually cannot find the case law you mentioned in the module.
Sorry, this is not in module. I have tried to incorporate my own works in consideration with the modules. I'll do one thing. After the session, I'll send you my PDFs.
Okay, sir.
So every one of you will get those PDFs, so you can just go through them. Correct?
Okay, sir.
Now, just summing up for the better understanding that what all things we need to be taking care of when we are drafting or even looking into a contract. It says, first thing, that a contract, just don't go only for standard form of contracts now. Just take it for general, traditional, any type of contracts, employment, work contracts, anything. It says important points are there. It says description of the parties to the contract. First thing that should be detailed in the contract is description of the parties, so that we can understand that who are the privy to this contract, that who are the persons who will be affected by any default of term and condition of this contract. If this contract is not executed, who will be the person who will be affected? Correct? So who will be the person who is claiming to be a plaintiff in this? Now, legal nature of the contract. That why this contract is executed. Is it a contract for services? Is it a contract for certain projects? Is it a contract for certain employment? Is it a contract for only work-based development or redevelopment in real estate sector? Correct? Then licenses and permits. If it's for, say, some land development or any industrial development or anything, so there are certain licenses. For example, if it's a real estate, then you have to take certain sanctions, you have to take certain licenses, work licenses. Say there are certain sanction plans which have to be taken care of when you're delivering those properties. Then you have to go for the occupancy certificates that is to be issued from the authorities, that this is a fit place to allot. So all those licenses and permits, they also need to be mentioned in your contracts. Next comes tax, duties and charges. That who will pay the duty charges if it's a product which is to be imported, who will pay the taxes if it's a commodity of that nature, what will be the charges, how these charges will be paid. So you have to also incorporate in your contract these points. Then it becomes quality, quantity and inspection. Now what we did was representation of a product or representation of a service, which is the core of your contract, because contract will only be for certain aspects, certain transaction, be it say work related, be it say some employment related, be it towards a product. For example, if it's a product or if it's a machinery, then you have to mention your quality. You have, because the major issue of dispute comes on this particular clause, that this was not properly detailed, that what will be the quality, quantity and inspection of the goods. Then how, if it's a good which has to be, say, delivered from different locations, that how it will be packed, what will be the packaging, how it will be transmitted, your transportations, is it insured or not, to what extent it will be insured. The example we just did, for example, there was a machinery which was imported from abroad in India, but what happened in that, it was to imported, it came by the sea route. What happened is they took insurance from port to port, but when it was unloaded from port and it was being delivered to the location, the vehicle which was carrying that machinery caught fire and this whole machinery got dismantled over there. So now the question was whether the person who has booked this machinery was eligible for any kind of damages or not. or who will be under liability to pay those damages, because that transit was only from port to port. So you have to disclose that also, that what will be the insurance, what will be the indemnity, how it will be indemnified in case of any loss, damage, or any demolition, or anything which is claiming any defaults. Then whether there are any guarantees or warranties, you have to mention that in your contracts. Then passing of property or passing of risk, that is it only a contract that will only do this, and whatever the risk, who will assess the risk? Is it a limited risk? Have we curtailed those risks? For example, if a developer is making some building, you have given the developer your land. Now contract is executed. Will that developer take care of any mishaps on that site? Will the developer be held liable for that, or will the contractor be held liable for that? So you have to mention that upfront, because you have to see, you have to apprehend that whatever down the line can be the possible probable disputes which can arise. One of the disputes is towards the quantity, quality of the service or the product in consideration. Second dispute would be between if it's an agreed party or not. If they are privy to this contract, then only they can claim. So parties should be declared properly in your contract. For example, if I am a party and I mention in that all my legal heirs and my agents or the persons authorized by me, they will have the equal right as I am having in this contract. So I am giving that to my personal persons whom I am authorizing, correct? But if it says only to the extent of the person A, then only that person A can claim tomorrow, nobody else. So you have to see, these kind of contracts are generally what, when it comes to, say, for example, there's a contract between two companies, a person and a company, or landlord tenant, correct? For example, tenant takes a property on rent. It says that, for example, tenant is Mr. A. If Mr. A during the tenancy passes away, then this tenancy will however be terminated, because the party to the contract is no more. But if it says Mr. A or legal heirs or any agent to whom Mr. A has authorized, so that tenancy, if it survives for say 1 year and Mr. A is no more after 2 months, so those people can come into the shoes of the Mr. A. So it says description of those parties. Now you have to see force majeure. These are boilerplates here. Proper law of contract, that what will be the dispute, how it will be governed, which law will be governed, whether alternate dispute redressal is to be mentioned over there, has been there. Now there is a precedent which says even if it is not been mentioned that arbitration clause will be there, but if it talks that in case any dispute arises, parties may sit and talk about this. What does this signify? It signifies that they are willing to go for alternate dispute redressal. So by virtue of this particular clause also, they can invoke arbitration. Otherwise, what will happen when arbitration will be invoked? The other party will say this is not a clause in this agreement or this particular contract. So you have to see that what is the proper law which is being governing this contract. Then settlement disputes and arbitration. So this is a broader view that what all will be incorporated in your contracts in a general terms, not specific to any specific contracts. You have to look, there can be other things also, like I said, termination, exit clauses, force majeure, and one more thing like calculated damages, or if it can be assessed, so that can also be annexed as a schedule. So you have to see primarily these particular important points when you are drafting a contract, or whether you are proofreading that contract, or you are just going through that contract to raise any area of defense. You have to see that whether these, at least these particular important clauses are there or not, to draw a line of any fundamental breach over there. Correct?
सर आर्बिट्रेशन एक्ट तो ये बोलता है ना कि जो आर्बिट्रेशन अगर आपको इन्वोक करना है तो आपको स्पेसिफिकली मेंशन्ड होना चाहिए कि आर्बिट्रेशन, मतलब जैसे तो आपने लाइन बोली कि वो विलिंगनेस शो कर रही है, आप कह रहे हैं एडीआर के लिए हम जा सकते हैं
जी
अगर हमारे विलिंगनेस है, लेकिन उसमें आर्बिट्रेशन के लिए ही जाएंगे। उसके लिए स्पेसिफिकली आर्बिट्रेशन एक्ट कहता है कि हमें उस
सेक्शन 9
मेंशन।
को इन्वोक करने के लिए, आई नो
हाँ,
दैट, बट देयर इज अ प्रेसिडेंट, आई विल शेयर इट विद यू ऑल. It says even if, see what happens is, to shed away the stress of multi-level litigations, court said ki if there is any clause which is similarly talking about these kind of provisions, then also we have to read that, even if it's not specifically written that they will go in arbitration. But if it says that we can represent it to a senior official and that can be adjudicated, what does it mean?
हाँ, मतलब
So if
parties
it
willing to pay,
willingness, so to that extent it is told that
that is
law of contracts, because law of
substance over
contracts will,
clause.
yes,
So it is substance over clause, I guess.
correct. So when you will be see these standard form of contracts, generally I don't know how many of you will be, in that area where you will be drafting them, because these are all pre-drafted. But on the other side of the table, I think most of you will be reading those contracts, because these contracts are generally coming from the clients who say that after executing these kind of contracts, there is a certain dispute which arises, and now we want a legal remedy to this. So to that extent, you can go through and again proof check these pointers for raising your defenses.
Okay.
Now, we are still left with our boilerplate clauses, because boilerplate clauses are most important aspect to be discussed and to be dealt before we start any factual drafting. Because see, facts will be given, but at least these main ingredients of your clauses should be clear to you, like representation, notice, your if there is anything which goes like a fundamental breach, then you cannot put those clauses. If it's against the public policy or unfair in nature, so you cannot put those clauses, because those clauses will be dealt by the clause of severability. We'll deal with that particular clause also, that what is law of severability, that only to that extent that particular clause can be waived off. Correct? So go through the module today. I think module 1 is complete today. You can go through that. By the meantime, I'll share you these PDFs also, where I have mentioned these pointers. You can just go through them also. Okay, I think 8:30 is there. I'll just leave you in that particular time, because you must have another session now. Thank you, everyone. Tomorrow we don't have a session. Okay. Thank you.
Thank you, sir.